Hey guys, this is Layla Shaver, owner and founder of My RA Lawyer. I wanted to talk to you guys because Thursday and Friday I was in Miami for a um, branding workshop, and a lot of the workshop dealt with, what are your beliefs? What's your mission statement? Who are you trying to help? Who do you really feel passionate about helping? And I had been struggling a little because I want to help everybody. But then when I got to talking and presenting in front of everyone, I realized a few things. So I'm going to read you what I wrote. So, and these are really true, what I believe. I believe advisors are afraid of regulators. I believe regulators don't actually care about investors, but about how much money they can get from advisors to fill their coffers. I believe clients or investors, clients of financial advisors, often don't take responsibility and know that they can complain to get out of a bad investment decision, thereby putting the financial advisor's lifestyle, life, business in jeopardy. I believe there should be responsibility equally between the advisor and the advisor's client, the investor. Now, as some of you know, if you reviewed my LinkedIn profile, I used to work for a firm that's no longer in business, but they were the firm that I started my journey in the securities industry with. So when I was in law school, it was, the market was crashing, had crashed. People weren't finding jobs. I needed a job. And my mock trial coach was in-house for a brokerage firm. And I really needed a job. So they were looking for a paralegal. So I was like, hey, I'll come in. Fine. So I went in and it was like, well, we need a paralegal. So you can work, in the meantime till we find somebody. I'm like, okay, yeah, sure, whatever. That's fine. And I busted ass. And my second year of law school, I was working part-time. I went full-time in the summer. And then by my third year of law school, I was working full-time at the brokerage firm and then taking whatever classes I could at night. And when I passed the bar the first time, they promoted me to corporate counsel. I worked for J.P. Turner & Company. Now, many of you know this firm. They had a reputation. Not a very good reputation, at least from the regulatory perspective. For me, it was great. I got a lot of experience, and I enjoyed the work I did. And I can say that at one point, things were getting so crazy there that we got like 13 or 14 arbitrations a week. And that went on for a period of time. So for me, fresh out of law school, it was great. It was exciting. I was getting all of this experience. But I learned some things working at a place like that where their emphasis on regulatory compliance was, let's say, less strict than perhaps other brokerage firms. And that is a lot of times, yes, the advisor was responsible for the complaint they received, and the complaint was just, and that advisor had to be disciplined. But a lot of times there were advisors that had to go and get something disclosed on their U4, or they were subject to an arbitration, or had to go into arbitration for something that really wasn't their fault. They went off of a document that the investor signed and, put that investor in certain investments per the parameters that they had discussed. And then the investor comes back and says, oh, well, I lost money on this. You didn't fully disclose to me what was going on. So yeah, I'm going to file an arbitration against you. And then all of a sudden this person who may have been an advisor for 5 years or an advisor for 25 years has a disclosure on their U4. That's all publicly available information. So now I look back at that time that I was at JP Turner, where I was fighting hard for that firm. And I was fighting hard for our brokers. And I was doing expungements left and right as much as I could. And I realized a few things. And I this last few days at this workshop has made me realize a few things about why I started this business. I love my advisors. I want to help my advisors. Because if the regulator really cared about the individual investor, places like JP Turner, they wouldn't just keep getting fined and fined and fined and fined and fined and fined over and over and over again. They take them out. They say, you're shutting down. We can't have a place like you. So for me, it's all about the regulators just want to take advantage. They know you as the financial advisor are scared shitless of them because they're going to come, they're going to put disclosures on your publicly available information. They're going to threaten your lifestyle. They're going to threaten the business that you have built for yourself. All this they know, and they're going to come after you, and then they're going to fine you or discipline you or suspend you or even revoke your licenses. And they know they can do this. And for me, it's just greedy. It's just greedy. You want to discipline someone who's really worthy of the discipline? Fine. But when you are trying to fine someone $10,000, $15,000, $20,000 for putting a disclosure, the disclosure was in there. It was just in the wrong place. And you're fining them $20,000? Really? What the hell is that supposed to accomplish? So I discovered that's why I started my RIA lawyer. I want to help the small guys. You know, when I was in-house, the brokerage firm came first. We were there to protect the brokerage firm. And if that meant the interest of the broker aligned with the brokerage firms, that was fine. But if it didn't, that was on the broker. For those of you who are brokers, you need to get your own attorneys when you get sued. When you become the subject of an arbitration, you need to go get your own attorney. So your interests are represented. And those of you who are RIAs and you're the owner and you're hustling and you're marketing and you're selling and you're dealing with investors, why the hell are you doing your own compliance? You don't know anything about compliance. You don't have the time for it. It's not the highest and best use of your time. Why the hell are you not using someone like an attorney who can review your shit, get your shit in order, and protect you from a $25,000 fine for putting a disclosure in the wrong place? This is why I do what I do. This is why I've discovered, I got into my core. Why do I do what I do? This is why. So I'm going to give you some examples. Okay, so I've got FINRA sanction guidelines as of April 2016. And let's pick one. All right, outside business activities, failure to comply, monetary sanction, $2,500 to $73,000. Holy shit. Let's go over here. We're going to look at Florida disciplinary guidelines for dealers, investment advisors, and associated persons. Let's look at investment advisor. Here we go. Advisor, books and records requirements. First occurrence, notice of non-compliance, a fine from $2,000 to $5,000, restriction or suspension for 5 days to over 30 days for a books and records violation. That's the first occurrence. Not a second, not a third, first. Let's see. Custody requirements for investment advisors. So first occurrence, again, we're looking at notice of non-compliance, a fine of $5,000 to $10,000. Where was I looking? Fine D. Yeah, $10,000. And then suspension from 5 days to over 30 days for a first-time offense. All right, let's go back. So come on, guys. I mean, this is ridiculous. So we're doing a video series. It's starting Tuesday. Visit us. We're going to talk about some of these things and think about what you're doing with your business. All right.